Good morning, everyone. This is Tim Hilton. I am a member of Husch Blackwell's eDiscovery Solutions team and a partner in our Labor and Employment group. We are excited to be talking with you today about the risks and benefits of permitting workers to use personal devices and applications in the workplace. We will also offer best practices and suggestions about policies for mitigating and avoiding those business and legal risks. Before we begin, I would like to cover a few housekeeping items. At the bottom of your audience console are multiple application icons for your use during the program today. I would like to take a minute to highlight a few key icons for you. If you have any questions during the webcast, please submit your question via the question box. We will try to answer questions during the webcast today, but if a fuller answer is needed or we run out of time, it will be answered later via email. We truly appreciate audience participation and encourage you to submit questions as needed. There is also an icon to assist with your viewing preferences. Accordingly, please note that you can expand your slide area by clicking on the Maximize icon on the top right of the slide area, or by dragging the bottom right corner of the slide area. Excuse me. If you have any technical difficulty, please click on the Help icon. It has a question mark and provides information regarding common technical issues with the webcast. A copy of today's slide deck and additional materials are available in the resource list icon that looks like a folder at the bottom of your screen. Today's program has been approved for Colorado, Illinois, Iowa, Kansas, Missouri, Nebraska, Tennessee, and Texas continuing legal education credit. Wisconsin and Virginia continuing legal education credit is pending. To report your hours in Illinois, Kansas, Nebraska, Tennessee, or Texas, click on the CLE widget at the bottom of your screen and complete those questions. A recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you. Joining me also today is Danielle Gilbert. Danielle Gilbert is also a member of the firm's eDiscovery Solutions team and is a litigator in our Austin, Texas office. Husch Blackwell eDiscovery Solutions team understands both the legal and technical side of the highly specialized eDiscovery field. We steer the logistics of eDiscovery from start to finish, establishing a transparent and trustworthy process and implementing standardized approaches to eDiscovery that are consistent, repeatable, and defensible. So thank you again for joining us here today. We're having a whole day of eDiscovery Day presentations. And today, Danielle and I are going to be speaking about BYOD, Bring Your Own Device, Risks and Best Practices for Allowing Workers to Use Their Personal Devices for Work. All right. A little bit on the agenda today. You should have an agenda slide up now. I'm going to talk a little bit about the basics of BYOD and its evolution. I'm going to talk about the business side of BYOD, specifically the business risks and mitigating those business risks. Then Danielle is going to talk about the litigation and eDiscovery risks and benefits of BYOD. And we will probably take questions at the end, but also if questions are submitted during the presentation, we are going to try to answer those as best we can. So we're going to start out with a few poll questions, and you should be able to answer these. We just kind of wanted to first get a take on what type of industry our audience is working in. So you should have a screen now that says, I work in the following industry. I'll give you a few moments to review and answer those. And just to know, I'm not going to read through each of the options, but you may need to scroll down to see them all before you answer. So I'll give you a moment to answer that. All right. All right, so it looks like we've got obviously a huge chunk of the audience working in the legal field. Also, the healthcare and manufacturing field are big. So that helps us just get a little bit of an idea of what our audience is interested in eDiscovery and BYOD are. We have another poll question coming up, and just to take a little poll at the beginning of, does your company allow or encourage employees to bring their own device for work? And the options are yes, many employees, yes, a few employees, no, we do not, or I don't know. And I'll talk a little bit about what those numbers look like as compared to what the general industry data looks like as we get into it. All right, so on the next slide, it looks like we've got a good split, and this is consistent with what I expected, that the plurality certainly allows for many or most employees to bring their own devices to work. There's a good chunk that does not allow it, and a good chunk that is not sure, and we can talk about that moving forward. So I'm going to talk a little bit about the evolution of BYOD, and basically I would say that the very basics of it deal with the cost savings and accommodating employee preferences weighed against the business risks and, the litigation risks of that can be associated with BYOD. As with any business decision, it's BYOD decisions are based on whether or not the costs and the risks outweigh the benefits of it. I did a little bit of research. This was slightly older data, but it was consistent with what our poll question showed, that indicated 59% of companies were using BYOD about a year or so ago, and there was another chunk of 13% that were planning to do so within the near future. So BYOD is no longer something that we're moving into or that is on the horizon. It's really the norm, or the certainly the majority of companies appear to be using or considering using some form of BYOD. So what does that mean? BYOD is when the employer permits the employee to, quote-unquote, bring their own device into the workplace. Now, of course, employees, even if you don't have a BYOD system, are going to be physically bringing their devices into work, but we mean bring in the sense of to use for their to use for their primary work device. It's popular with companies for two reasons: cost-saving efforts, and we also see increased productivity, but there are risks along with that, and/or to accommodate worker preferences for their devices and the convenience of employees in using their own device. This inevitable and likely permanent, or as permanent as anything in the technology world is, trend brings with it myriad issues that are created by BYOD policies and initiatives. And those are going to fall into the categories of the business risks and the litigation risks. Now, it's not only BYOD that we talk about in this space, but there are other types of BYO programs. It's more than simply allowing employees to use their personal cell phones and laptops, but that is what we're going to focus on today. But some of the other options that your company may be using or may have are what we would call BYOA, bring your own access, where employees provide their wireless access to organization systems, often through the use of mobile hotspots. BYOE is a bring your own encryption, a cloud computing security model that allows cloud service customers to use their own encryption software and manage their encryption keys. That may also be called BYOK, bring your own key. BYOI is what we would call bring your own identity, where employees use third-party systems such as a quote-unquote login through Facebook option as their credentials for accessing the organization systems. Bring your own network where employees are using their own personal network instead of the organization's network, and with, as technology advances more and more, bring your own wearable devices such as Apple Watches and things like that, which can ultimately be connected to the company's systems. So I'm going to talk about the business risks. This is not necessarily, when we talk about cost benefit or whether the risks outweigh the benefits, we're not necessarily only talking about the bottom line in a tangible money sense, but basically all the risks of BYOD that are not directly related to a legal claim or the eDiscovery process that goes along with a legal claim against the company. So what are the types of considerations that companies look at when deciding, whether they are going to allow BYOD? There are a lot of organizational considerations. Organizations should consider their business needs and objectives, their legal rights and obligations, and the rights and expectations of their employees when deciding whether they're going to require, allow, or somewhere in between with respect to a BYOD system. So some of those considerations are: what are the employees' role within the organization? What are their duties? Do they need access to company systems outside of normal work hours? Whether are they hourly or salary, which as a labor and employment lawyer, I can tell you presents special wage and hour and labor and employment risks associated with whether we're allowing hourly employees, non-exempt employees from the wage and hour laws to be able to access company systems outside of normal work hours, and the overtime risks that can create. Considerations of what type of information will be accessed. If you are working in obviously all companies have important confidential information, but if you are operating in a space that has highly sensitive proprietary trade secret or things like patient data, student data, things that require more legal protection than normal company confidential information, that's definitely going to be a consideration that you go through in whether or not and what type of BYOD you're going to have or not going to have. Obviously, companies are going to want to consider their size and their ability to absorb the internal IT costs that are associated with a BYOD program. It can create a lot of, there's a cost-saving aspect. Obviously, the company doesn't outlay the money to purchase the same device for all the employees, but there can be costs associated with having the hardware and software in place to support a variety of different devices and a variety of different brands of devices, and the infrastructure that goes into building that. Again, I did some research and found some data suggesting that companies can save $3,150 per employee per year on a BYOD system. But of course, that's going to vary significantly from company to company. Don't be taken in by a vendor who's going to tell you that you can definitely save this amount of money per employee per year or anything like that. And again, that's only the dollars and cents. It does not tell you about the productivity costs or any of the other business type risks that are associated with BYOD. Company culture and other factors are going to be things to consider whether or not there's going to be a BYOD system put in place or expanded. And while it does seem like BYOD is the majority right now, there are information out there talking about reasons that companies are getting rid of BYOD, companies that have put it into place previously and have decided that it doesn't work for them for whatever reason. First among that would be security, and that was really number one and number 1A and number 1B. Again, all companies are going to be very focused on the protection of their company confidential information. And BYOD can be kind of a Pandora's box. Once you start it, you're giving up a significant amount of control, both as a technical and as a practical matter, over company data. And if that's not something that works out or is acceptable from a company standpoint, then that's a reason to get rid of it. Employee behavior too unpredictable is a reason that companies are getting rid of it. As a labor and employment lawyer, I can tell you that can happen. Companies aren't always seeing the cost savings that they expect. Even when there can be cost savings, they find that there can be unpredictable costs, even if they're saving a little bit of money. Risk of data loss, and also there are some situations in which companies are finding that their employees don't want it. So, talk a little bit about some of these specific business risks. As I mentioned, security is number one and number 1A and B and C of the business risk associated with BYOD. We're giving up company data, removing it from the company's control in some level. That's unavoidable with any BYOD system. There's going to be situations in which employees are going to have different versions of company documents. It can be easier to move company documents to cloud storage, which may be valuable for employees in some situations and also presents a security risk. You're going to have abandoned data out there, which can present both a business and a litigation risk. You're going to have situations with employees having personal backups of company data, and there's going to be security risks associated with when you have a departed or a terminated employee. It's going to be very important to have a policy in place to deal with a departed or terminated employee, but it's also, there's going to be practical situations associated with actually enforcing that policy when there's when somebody leaves the company and they have company data on a BYOD device. Other business risks associated with BYOD. It can be difficult to enforce document retention policies, and that can kind of cut both ways. And I'll talk about that on the next slide, but there can be risks and difficulties with enforcing the company's document retention policies. Again, you can have as strong or as powerful or well-written of a BYOD policy or document retention policy as can possibly be written, but when you're giving up some company security of data, there can be practical issues with enforcing that. Risks associated, again, with employee privacy rights when there's going to be personal and company data on an employee device. For example, the company needs to get that device. That presents an HR risk and associated, employee privacy risks of seeing somebody's personal information, their personal correspondence, and those can be mixed. Whether something is business, company, or personal document may be questionable at times. Along those lines, you're going to have shared backups of mixing company and personal data. I can tell you from working on labor and employment cases, people's text messages are going to, with their coworkers, are going to run together. One time they're talking about the person raising a discrimination claim who we're counseling or going to consider terminating, and then we're talking about purely personal matters. So those are the things that we see when we have the mixing of personal and company data on quote-unquote personal or BYOD devices. There's a risk of off-the-clock work. As I mentioned, alluded to this a little bit earlier, as a labor and employment lawyer, this is something that we think about a lot. This is a mixture of a business and litigation risk, but like most of these are going, a business risk can ultimately develop into a legal risk. And companies ought to consider whether they allow certain or any hourly non-exempt employees to have access to company data off the clock, because that presents issues with tracking whether or not people are working and when they're working, and making sure people are reporting their hours correctly. And again, I alluded to this earlier, there can be an unpredictability of costs of supporting a variety of different devices and how and the infrastructure necessary to create that. So how do we mitigate some of these business risks associated with BYOD? One of the primary tools that companies use excuse me, to manage a BYOD system is what's called mobile device management software. If you, like me, are on a BYOD system, you have an app that has been installed on your phone, hopefully by the IT system, that functions as a mobile device management software. This can provide enhanced security, virus protection, and encryption, in addition to what's available on the device to try to uniformize the different security regimes across a range of brands of devices. It provides the company with the ability to locate and wipe the device if needed. It often can create file storage, such as a container where business data is allowed to be stored on the device that can provide additional security beyond what is inherent to the device. Typically, I mentioned the location tracking. That's a common feature of MDM software. Typically, we want to have that turned off in the normal course of business, but it definitely does come in handy in the terminated or departed employee situation. I've had labor and employment situations where the employee is telling us that they lost their device, and the company is able to bring up the MDM software and say, no, actually it's in your bedroom right now, and so that can be very valuable. But for privacy reasons, in the normal day-to-day situation, you typically, companies are not going to have those turned on. In addition to MDM, there needs to be policies and procedures in place to spell out what the terms of the BYOD program and what the expectations are. That should often give the company the right, obviously, to define appropriate use of the device, similar to the policies you're going to have in place for appropriate use of your computers at work. Important to have policies in place related to appropriate use of a BYOD system. You can consider in security situations whether the policy should have something like prohibition against using cloud storage or against using something other than the typical company cloud system. We strongly advise that this not simply be a policy that is in a handbook somewhere, but that program participants sign a separate acknowledgement of BYOD rules and terms of use. Another tool of mitigating these risks is consider excluding high-risk employees from BYOD. Now that may be, as I mentioned, a very broad scope of whether we're going to even allow non-exempt hourly employees to participate, or whether there are certain groups who we expect to have access to certain data that we can't accept that risk, that security risk. There may be certain groups of employees who we see a very high turnover on, and we want to consider whether we exclude those people from a BYOD system. And there can even be a targeted situation in which, well, this is somebody who we know is planning on suing the company, or is planning on leaving the company and going to a competitor, and we want to consider whether we're going to allow that person to continue participating in the BYO system. So what goes into drafting the BYOD policy? It needs to clearly set out the circumstances for and types of information that can be stored on the device, and how that information can be subject to monitoring, access, or deletion by the company. It should address the ownership and costs of the device and the data costs, including intellectual property licensing considerations and what happens in the event of termination of the employment relationship. It should explain that, and Danielle's going to talk more about the discovery and the litigation side, explain that there may be unique and relevant ESI, electronically stored information, that may be subject to discovery. And we're going to always want, as much as possible and as much as practical, to discourage any storage of unique ESI, meaning a piece of ESI that is not found anywhere else other than on the person's device. We want to keep that on company systems, not on a personal device, as much as possible. Again, identify acceptable use restrictions and the consequences of violating those rules, similar to the general computing use policies. The policy should also identify steps that the organization requires to be taken to segregate personal and business information. Employees should be informed about how the device management, how the MDM system is going to work, and acknowledge that, so that there's no claims later on of improper or monitoring of personal devices without permission or without employee knowledge. It should address the potential for litigation, investigation, and regulatory disclosures, and the expectation that the employee will provide both access to the device and information stored on it when requested by the company in such a situation. The organization should carefully consider the implications of insisting on access to the device and the data on the device, and it should highlight the potential for a waiver of attorney-client privilege if the employee fails to protect privileged ESI. Again, that's a litigation risk that Danielle is going to talk about as well. Policy should explain security measures that are in place to protect business and personal information on the device, as well as the physical security of the device itself. It should address privacy to be consistent with other organizational policies, including the information management policies, employee benefit, and other HR policies, and any other policies that are specific to your organization. And finally, we recommend that policies address the user's obligation to update applications and patches and things like that to MDM software as needed. And we can, I know that there's a lot that I just went over that should go into a BYOD policy or a BYOD acknowledgement, and we can certainly talk about that in more detail offline. And finally, again, what do we do if the employee leaves? This is or departs the organization, especially if it's unexpectedly, whether voluntarily or involuntarily. Again, there's no perfect solution to this problem, but the MDM software provides remote access for wiping, location, and deletion, and of course, policies and even employee contracts and agreements with the company can govern what will happen in the departure situation. So that's those are my slides on the general ideas behind the business risks associated with the BYOD system and how to and some general tactics on how to mitigate those risks. And now I'm going to turn it over to Danielle, who's going to focus on the legal and litigation risks of BYOD.
Good morning, everyone. As Tim mentioned, I'm Danielle Gilbert. I'm a litigation associate in our firm's Austin office. I handle a variety of business litigation, including healthcare, real estate, contract disputes, whatever you need. So today we'll be discussing the litigation side of BYOD, but before I start, I'd like to have everyone take a poll about BYOD. So the poll is, does your company have a BYOD written policy? Yes, no, or I don't know. So I'll give you a few seconds here to answer. Okay, let's take a look at those results. All right, so that's a lot of no's, a lot of yeses, and a lot of I don't know. So of course, the no's are, it could be, an intentional thing, because as we'll talk about in just a moment, even having a BYOD policy does have litigation implications. I don't know is not necessarily a great thing, because that means that the companies that do have BYOD policies aren't necessarily doing as much as they could be doing to maybe inform employees about these policies. So we'll talk a little bit about some of the litigation risks and how we can mitigate those, and a lot of it has to do with following Tim's advice that he gave us earlier. So let's do one more. So has your company been involved in litigation where personal devices were collected? Has your company been involved in litigation where personal devices were collected for the purposes of that litigation? Yes, no, I don't know. Give you a couple seconds. All right, so it looks like a good number of companies have been involved in litigation where personal devices were collected, and I think as we go into the future, the number of yeses is just going to increase and increase as BYOD becomes more universal. So let's talk a little bit about the litigation side of BYOD. Of course, BYOD complicates discovery. As you can imagine, BYOD increases the burden and cost of eDiscovery during litigation. So first, one of the major reasons is because preservation can be very difficult, as Tim was discussing, because there could be relevant responsive data stored on a bunch of different employee cell phones or tablets, and this means that the company has less control over those devices. Another issue is that unexpected events can happen. So, for example, an employee may refuse to assist the company in collecting the data on his or her device and say, no, I'm not taking my phone to the vendor to be scanned. I don't feel like I should have to. This can be problematic because a court might say, well, the employer should have anticipated that this could happen and had better policies or programs or procedures to prevent this type of situation. Another situation that can arise is the employee may not own the device outright. For example, their device might be on one of those payment plans where the service provider and employee jointly own the device until it's completely paid off, which could present a control issue for the employee whose device needs to be collected, or it could be owned by a spouse or someone else in the family plan. And this is called dual ownership, and it certainly can present a problem with BYOD. Another situation that can increase the cost is where, per the company policy, business records are only kept for X number of years. I know in the healthcare industry it's usually 7, for example. So let's say that that's the policy. An employee could download business records to his or her tablet without the company's knowledge. And then if litigation were to occur, those records, if responsive, would be discoverable and would have to be collected. So that's always a danger with BYOD. So is data on a BYOD device discoverable? Federal Rule of Civil Procedure 26B1 defines generally the scope of what's discoverable in litigation, and it states, unless otherwise limited by court order, the scope of discovery is as follows. Parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case, considering the importance of the issues at stake in the action, the amount in controversy, the party's relative access to information, blah, 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 blah. I'll let you read the rest of it, but what I think you can gather just from even that beginning of the rule is that this is a really broad definition of what's discoverable, right? This can be interpreted in a very, very broad way, and often is. So in litigation, unfortunately, I hate to tell you all, BYOD devices are indisputably considered sources of potentially relevant information, and there is no exception just because that device is also used for personal purposes. So when a company does BYOD, does an organization have a duty to preserve and collect data from a BYOD device, and under what circumstances? The first thing that we have our clients do is we ask, 2 questions when determining whether they have a duty to preserve and collect data from its employees' devices. Number 1, does the device have relevant data? That's kind of intuitive, right? Is it relevant to the litigation? And the second question is a little different. Is the relevant data unique? And we'll talk about what that means. So the Sedona Conference, which is it's an eDiscovery think tank that many judges rely on for their eDiscovery guidance. It states employee-owned devices that contain unique, relevant ESI, electronically stored information, should be considered sources for discovery. So things that are not unique are things like company email, if that email is synchronized with the company server. So that's not unique, right? It's stored on the server. It's much less costly and burdensome for the employer to collect that from the server rather than going to every single employee and saying, hey, we got to collect your phone to get the email off of it. So that's not considered unique data that would need to be collected from its cell phone. Unique data includes things like, that probably wouldn't be on a company server, like text messages, voicemail, photos, video, and unique versions of documents like I talked about earlier. You never know, what if your employee takes a screenshot of some edits that they made to a document and delete the file from their system. So those are the types of unique things that would potentially need to be collected for the purposes of litigation and to preserve, of course. So let's talk about some other factors that are used to determine whether a company has a duty to preserve data stored on a BYOD device. So the question we ask after whether it's relevant and whether it's unique is, does the organization have possession, custody, and control over the BYOD device as defined by Federal Rule Civil Procedure 34? I will spare you from reading it to you, but possession, custody, and control, we'll talk a little bit about how that's defined in a little bit. Second, is the data unique, which we discussed earlier? And then third, is the collection of BYOD devices proportional to the needs of the case? And so, for example, if it's a very minor, small case, low damages, and devices could be relevant, but they aren't going to be super important to the litigation, but it's going to cost a bunch of money and time to collect them, then you probably have a good argument that BYOD preservation and collection is not proportional to the needs of that minor case. So these are just a couple of little collection issues that you come across when determining preservation and collection issues. Does the company have a duty to collect data from former employees' BYOD devices? Sometimes if that employee is still deriving some sort of economic benefit from the company may have a duty to collect. So just because they're gone doesn't necessarily mean that the company's off scot-free, and that's kind of a fact-intensive inquiry. And then the second part is notice and consent required. So as Tim was mentioning earlier, having a policy that requires notice and consent for collections and for just BYOD usage in general is super important. So we talked a little bit about what possession, custody, and control means. So case law has formulated some standards for when a company has possession, custody, and control of a device. One of the standards is the practical ability standard. Does the party, the company, have the right, authority, or practical ability to obtain the information? So can they practically obtain the information? It's not something that they're just never going to be able to get a hold of. Another standard that's also used in the U.S. is called the legal right standard. It's kind of what it sounds like. Does an employee have legally any right to the data on the device? So one example we like to use is that an employer doesn't have a legal right to a device that's only used for personal use by an employee, but they would have a legal right if company policy directs the employees to use text message for business communications. And then, of course, there are a number of gradations and variations of these two standards throughout many jurisdictions. So one, just for an example, it's tough to argue in court that an organization does not have control over the high-level employees. The C-suite, legal, HR, managers, owners, those types of people who probably use their devices for work purposes all the time and are higher level within a company are considered to be under the control of an organization. In fact, another thing that may demonstrate control is the fact that the company has a BYOD policy. Maybe the BYOD policy allows, the fact that it allows employees to use their cell phone, it could demonstrate that the company has control over that device. Okay, so the Sedona Conference, which, as I mentioned earlier, is like the authority on eDiscovery, gives us some guidance on how to formulate a policy that will mitigate the litigation costs and risks with BYOD. And so they have these principles. And Principle 4, which is the one that's on the screen right now, is the one that it kind of gives us a guideline about when storage and preservation and collection is required. So it says what the policy should address. So it says an organization's BYOD policy and practices should minimize the storage of and facilitate the preservation and collection of unique relevant ESI from BYOD devices. If your policy can state, you're not supposed to text about work, you're not supposed to leave voicemails about work, things that can eliminate unique data from being stored on devices, that will serve you well in litigation. You won't have to collect as many devices, or at least if you don't collect the devices, you can say, hey, we had a policy that said this employee wasn't supposed to do this. So proactive BYOD management can reduce discovery costs by limiting or excluding unique ESI from the BYOD device where practical. Striving to ensure that all organization ESI is transmitted, received, or stored on the BYOD device is also captured on the organization's network servers or other centralized storage that are under the organization's control will save so much money for the company instead of having to collect the individual devices. Collection and review of text messages is super expensive and super time-consuming. Those of you who polled and said that, yes, you have had BYOD litigation where BYOD was involved and collection of cell phones was involved, you know this. If you can avoid having to do this at all costs, it will save your company money. Of course, this is not allowing employees to use devices for certain things like text messaging or voicemail is not practical for all companies. I understand that. I know for my job I'm available outside of business hours. I text with clients and my colleagues, and it's kind of a risk that our companies take. But to the extent that you can eliminate that for employees that don't need to do those kinds of things, and don't need to make those kinds of communications, it will at least minimize some of those costs during litigation. So here's the best part. If you really do comply with Sedona Conference Principle 4, and you have a policy that addresses the things that Principle 4 wants you to address, it's Principle 5 under the Sedona Conference. Principle 5 states that where an organization has adopted and implemented reasonable BYOD usage policies and practices to prevent unique relevant ESI from being stored on BYOD devices, the organization should not be required to preserve or collect ESI from the BYOD devices. So if you have a good policy, the Sedona Conference says you shouldn't be forced to produce, preserve, collect the ESI from those BYOD devices. Now, that's not to say that every judge agrees with the Sedona Conference. It's not the law. So take it for what it's worth. But at least, if you have those policies in place, some jurisdictions really will potentially have a lower requirement for whether you should have to collect ESI. So let's talk about some overall tips for BYOD eDiscovery. The best thing you can do is, like I mentioned earlier, do what Tim says. Ensure that there are reasonable steps taken before litigation arises. This can include creating consistent policies and practices regarding legal holds and when and how employees are notified about their duty to preserve their BYOD devices. Of course, these things need to be tailored to the company's business, your litigation portfolio, and risk appetite. And then creating preservation and collection plans and workflows and checklists, which I know sounds very boring, but if you can create a workflow that states when the duty to preserve is triggered, when collection happens, what a company has to do and what employees have to do if a preservation duty is triggered, and outlining all those things before litigation happens, every time that litigation occurs, it will run so much more smoothly. You'll have a much lower risk of spoliating evidence and having to deal with that down the line, which we all know is not fun. So just creating, having all of these policies and procedures in place and having workflows and checklists for how to deal with preservation and collection will be super helpful to your company. And we help our clients with that with some regularity. Okay, additional tips. Custodian interview. So custodians are people whose devices contain discoverable data that has to be preserved and collected. Interviewing those people to find out where are all of your files kept, where are all the possible places where data that's unique and relevant is stored. So here are some questions that you can ask a custodian that would be helpful to investigating this type of issue to ensure that all of the relevant ESI is preserved and collected. So number one, ask the custodian, how does the custodian use the device for business purposes, right? Do you text? Do you leave voicemails? Do you send each other, screenshots of your changes to this document? What do you use the device for? Does the custodian use communication programs other than company email for business purposes, text messages, chat programs, social media platforms? I know a lot of the healthcare groups that I work with, they have all sorts of programs that the physicians use to communicate. And then, of course, we need to find out from the custodian, is the information on your device relevant and unique? Has the device been backed up, and could those backups contain relevant, unique data? With iPhones, people say, oh, I deleted those text messages. Well, they might be on your cloud from all of your iPhone backups that you do periodically, even though you deleted them from the physical device. Has the custodian stored company data on non-company cloud storage? I see a lot of times where law firms, usually the smaller outfits, will use Dropbox to send over their clients' files, and I am very suspicious that they actually go back and delete the client files from their Dropbox server or the Dropbox account after they send over the documents to me via Dropbox for discovery purposes. And so, having that technically could be considered in the custody and control of a company if that company is a client of that attorney, and that attorney is an agent of the client, obviously. So that can be an issue, certainly. And then the last thing that really should stick with you is document the company's decisions and actions regarding BYOD, regarding all of these, preservation, collection, all of that. Just make sure it's all documented. You don't want to say, oh, we told, this person not to text, and they, I don't know why they did, and you don't have it documented. It's not going to be very, very persuasive to a court. So let's talk about sample language regarding access. This is a sample policy for BYOD to have your employees, that you could have your employees sign. Just a little free legal advice, only kidding. But here is, I'm going to read it to you just so you get the full gist. In exceptional situations where necessary and permitted under applicable laws and regulations, the company may request access to my personal device for purposes of assisting with investigations, e.g. in cases of an attempted attack or intrusion by a third party, litigation, or resolving security incidents. I agree to assist the company with reasonable requests for such access, including providing my personal device and any passwords necessary to access my personal device and related data. So you see, that's important because, like we were talking about earlier, sometimes employees will say, well, I don't want to, or I don't have to, or that's my personal device. But if they've already consented in writing to doing this, it gives you a little bit more muscle. To the extent permitted under applicable laws and regulations, I may exercise my right not to provide my personal device. There are some laws in certain jurisdictions, I know especially overseas, that really protect the private information of employees. So make sure you check with a lawyer about your local jurisdiction and whether you can just have your employee waive all the privacy rights to their phone. From time to time, company may institute a legal hold or conduct an internal investigation. If that legal hold or internal investigation implicates data stored on the user's personal devices or information stored by the user's service provider, then the user agrees to cooperate with company regarding preservation and collection of such data. So, that's an example that we like to provide that would be useful in litigation if you have any sort of spoliation issues or if you're trying to get a collection from an employee. So having a policy like that is always very helpful, and make sure people, like Tim said, make sure it's not just in a manual somewhere. Make sure people read it, they sign it, you do presentations on it, you do trainings on it periodically. So takeaways from today. An organization should really consider its own business needs and objectives, the expectations of its employees and customers, and its legal and compliance obligations to evaluate whether to adopt a BYOD program. Again, for many types of workers, mobile access may only provide a slight benefit while substantially increasing the risks to the organization. Then once the organization adopts a BYOD program, it needs to ensure that business information is protected from unauthorized access, disclosure, or use. And then, of course, the organization should adopt policies and practices to prevent unique, relevant ESI from being stored on the BYOD device, to ensure that a court will agree that the organization should not have to preserve or collect the ESI from BYOD devices. So with that, thank you all very much for your time, and if you have any questions, please submit them through the program as Tim indicated, and we'll get on trying to answer those.
Thank you, Danielle. Yeah, please do go ahead and submit other questions that you have. We have one here that that's a little bit specific, but I'm going to talk about it because I think it bleeds into the importance of having a policy. And the question is, what happens in a situation if the employee who owned the BYOD device dies after leaving the company? How should the company handle that? And I will candidly say up front, that's not a situation that I have dealt with, and I think it will be difficult to navigate. I'm not sure that there's a perfect solution for what's going to happen in that situation. But I think it's that and situations like it can highlight the importance of having a clear policy on the BYOD program, including one that spells out company ownership of company data. And for example, if you simply had a BYOD program with no policy in place, or a policy that didn't talk about the ownership of the data, I think you might be in a harder situation of trying to navigate that employee's estate or something like that. Obviously, if the employee owns the device, the company can't do anything about that. But I think we would have arguments that we would pursue, and hopefully, it could be handled in a relatively amicable way to say, look, we recognize the estate owns this device. The employee acknowledged and agreed to these terms and this policy when they used the BYOD system, and so we have a situation where company-owned data is on this privately owned device, and we need to talk about the best ways to get it back. And the mobile device management software could also probably help there as well. And certainly I can speak with that individual in more detail if that's a specific situation that we're dealing with and how we might navigate that. So thank you very much for joining our program today. We hope this information provided was helpful to you and your organization. If you have not already, please click on the survey icon at the bottom of your screen to complete our short survey. Feedback will assist us in providing quality programs in the future. As a reminder, this program has been approved for Colorado, Illinois, Iowa, Kansas, Missouri, Nebraska, Tennessee, and Texas CLE credit, and that is pending in Wisconsin and Virginia. A recording of this webcast will be available tomorrow for watching and sharing, and once available, a link to the recording will be emailed to you. This concludes our webinar. Thank you very much for joining us.